All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV 220153, Dawson v. Dawson. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and we have discussed this case in conference. And with that, counsel, you may proceed.
Thank you. May it please the court. My name is Rich Peters. I am attorney for appellant Livia Renee Dawson, who is present in the courtroom over my left shoulder. I've been her attorney since 2011, 2012, when the initial divorce proceedings were commencing. We're here today because husband, despite significant earnings, failed to pay his spousal maintenance obligation for a period of 28 months.
Okay, counsel,
Yes.
let me jump right in.
Sure.
The first question in my mind is, in your brief, you state that a contempt finding is crucial and necessary so that wife can be awarded the interest which had accrued between September 2018 and March 2021 when husband made the $29,000 payment.
Yes.
What is the authority for that there needs to be a contempt finding?
And perhaps the contempt finding phrase was not the appropriate phrase. My sentiment, my thought was, if the court believes that it was improper for him to not pay his spousal maintenance, then it's vested when it was due. If there was no magical automatic modification when he retired, then his spousal maintenance continued to be owed. He failed to pay it. He knew the order was there, and because the installments are vested when due, that interest should accrue.
That's not all that's required for a contempt finding, and because these payments become judgments on the date they're due, statutory interest runs. That entitlement would exist with or without a contempt finding, and here there are circumstances that seem to indicate that one essential element of contempt may not have been met. So I'm not sure that it's essential for us to even review that question, a question over which we lack appellate jurisdiction anyway. We'd have to exercise special action jurisdiction as an extraordinary matter just to review it, and it doesn't seem to be necessary to your position in the case at this point.
And again, perhaps the phrase a contempt finding, I was referring to a finding that he knew about the order, he did not comply with the court order, and he was aware of the court order.
None of that's necessary.
Understood.
The statutory interest runs on a judgment. It doesn't matter if he's, frankly, it doesn't matter if he's even alive.
And Your Honors, I did argue in other places in the brief that just the fact that the spousal maintenance payments were vested when due also would warrant the accruing of interest.
All right, now let's move on to my other pressing question,
Sure.
which is, so he stops making payments, and when he, according to his testimony, believes that she is starting to receive monies directly from the federal plan. And he stops making payments for a period of time, they go back to court, and now he makes a lump sum payment. And we can agree he made that payment because he owed her that money, right, for
Correct.
spousal maintenance. We agree on that?
Yes, ma'am.
It was not a gift.
Yes, Your Honor.
Okay, so so at some point, because the monies were being reserved, we don't know why, but for some reason the federal government is accumulating her share of the retirement, and at some point disperses that to her, right? And so why is it that she should be able to keep the money he paid and also the monies that came from the plan? Isn't she getting a windfall?
So, and that's what the court ordered. I mean, that's the entire question of this case.
No,
So,
that's my question to you.
Okay.
Why should she keep both amounts?
we think that he had the obligation to file a petition to modify to put her on notice that there was going to be a modification of spousal maintenance. Because he did not file that petition, ARS 25-327, she had no notice that this was occurring. Had she started
What about the 2017 proceedings and the order that said that there would be a modification when she received when she started to receive from the plan.
So again, if your honors are interpreting that to mean that he had no obligation to follow through with 25-327, if that language was sufficient, significant, descriptive enough to result in what, again, I'm calling a magical automatic modification of spousal maintenance, then that resolves the entire case.
It really wasn't magical. It was a court order. Did he not have an entitlement to rely on what the court said?
But if Your Honor, if you will read what the court order says,
Yeah.
it says, first of all, it incorporates the initial decree, which says may be entitled to a reduction. So how can we ignore that it's referring to the initial decree? He changes the word to will, not shall. I suggest in my statement that will is not the same as shall, especially in that order. He uses the word shall 18 times, and I don't know the exact number.
You know, I fought against the removal of the word shall from the rules, and I think I was unwise to do so, because you have just pointed out why shall is a problematic word. In this context, are you suggesting that shall is directory and not mandatory, or what's the difference between shall and will?
All right. I think shall is mandatory, and I think will is a description of some future event that may occur. It's not. I don't believe will is a directive. Is
So
a mandatory.
if I will meet you for lunch today, maybe I will, maybe I won't.
I agree.
Really? I mean, if you tell your client you will file a document, can the client rely on that? I think will is a pretty clear word.
And I'm just trying to convince you otherwise, Judge, that because the court used shall, because the 2017 order used shall numerous times, when they incorporated first the 2012 decree and then used the word will and added other obligations, by the way. It wasn't just that one.
You sought a remedy that could have placed husband in jail. And are you saying then that husband sees that he's not receiving a portion of his money, and so he stops making payments, but because he should have parsed the difference between shall and will, he is somehow subject to incarceration? That seems... I mean, you and I can't figure it out together. How is a layperson supposed to figure out the difference between shall and will?
You know, the testimony is very clear that he was aware in 2018 that she was not receiving her share of retirement. He continued to not pay spousal maintenance.
But he wasn't receiving his share of the money either, right?
Exactly, Your Honor. And
So he's supposed to be the bank.
hers. Sorry.
He's supposed to be the bank and double pay, so he doesn't receive the income that he might receive to pay the spousal maintenance. For whatever reason, the benefit plan isn't sending the money where it's supposed to go, and so he's just supposed to make up that difference, which I guess he ultimately did. It seems that the contempt is a pretty harsh remedy to seek in that situation, because mostly when we see these cases, everybody knows the payments aren't being made, and one party is profiting to the detriment of another. Here, neither party was profiting.
When we pled contempt, he had not paid a penny. He didn't pay a penny for months after we pled contempt after he was served. He then finally paid a lump sum, always had the ability to do it, and we withdrew our petition to modify, and I believe we withdrew the petition for...
But counsel, just a moment. Wasn't it reasonable for husband to believe if the monies are not going to him, that they're being held up somewhere and at some point they will be dispersed? I mean, the feds may be slow, but they're not going to keep the money.
And again, if the mere fact that he retires is enough to warrant a modification, a de facto retroactive modification of spousal maintenance, then my arguments are not convincing to your honors.
We know from the 2017 orders that it was not an absolute final, in the sense that we would not look at these awards ever again, right? It was not X amount of dollars and that's it.
Correct. It was certainly not final. It was still considered a lifetime award, subject to future things happening.
Exactly. So at some point, he stops receiving a certain amount of money from his retirement, or doesn't receive it in the first place. Wasn't it reasonable for him to think this money at some point will be released? I mean, it's being piled up somewhere.
And if that's towards the contempt argument, then perhaps that is. But Is it reasonable to say I don't have to comply with ARS 25327? I don't have to file a petition to modify?
Well, the
And get
order
her servant provider
says,
notice of it?
the order says that spousal maintenance will be further reduced by amounts wife receives from the distributions of
Right.
husband's Border Patrol and Marine Corps retirements, right? Will be reduced by a specific amount. If it had said shall be deemed at that time to have been reduced, I assume you would have no argument. So again, we're talking about verb forms as the basis for wife receiving double payments.
How come we don't review the rest of that paragraph? How come he's not obligated to do the next thing?
Which
It
is?
says, father shall submit a new income withholding order to the clerk of the court.
Okay, an income withholding order used to be called an order of assignment.
Correct.
But changing the order of assignment is a ministerial task. It is not a request for a judicial ruling. And in fact, the court would never have reviewed such an order if it had been submitted, because there's no request for a decision associated with it. It is simply a ministerial implementation of what the court has already ordered, is it not?
Whether it is or it isn't, he is required to do it. And whether...
Okay,
whether,
well, here we are now. So he was required to pay a certain amount of money.
Right.
She files and says, enough is enough. I've told you when we flew our child to college, and I'm tired of talking to the feds. You've talked to the feds, or so you say. We've gone back and forth, and I'm still not getting any money. So I'm taking you to court. And she takes him to court, and he says, okay, I've tried all I could think of, but here we are. I'm being hauled back to court because I'm not meeting my responsibility. Here is the money. Okay? Why does she still get to keep the money after that? That's the part that I'm not grasping.
So I think it's because he didn't comply with 25327.
But he paid her. He paid her.
The orders say that his spousal maintenance obligation doesn't stop until she starts receiving the OPM. And she didn't start receiving it until litigation. He didn't pay until litigation.
But he paid.
But he has paid. And so, Your Honor, is my client entitled to interest in the interim? We were only going to court. We weren't asking for contempt. We were going to court for interest for the period of time she hadn't been paid. We were going to court for attorney's fees because she had to pay a significant sum of money to pursue that interest and force him to pay. We also don't, and again, yes, we don't think it was appropriate that the court ordered her to reimburse him $36,000 because we think he still had the spousal maintenance obligation per 25327.
Which he met when he was brought to court.
I agree. I saw on TV last week, Terry Goddard, if you rob a bank and you bring the money back, there still should be repercussions for the fact that you robbed the bank.
If you rob a bank.
He didn't pay. Yes, he paid after I sued him. There still should be
So
repercussions.
if you rob a bank and you bring the money back, you're still held liable for the criminal act of robbing the bank. But should the bank then get the money from the thief and also from the insurance company?
So I go back to my argument is that
Well, should
there
they?
was no magical, in this instance, no. There was no magical modification
Just a
because...
second.
Can I
Just a
jump
second.
in for a second
I
here?
apologize.
What if you don't rob a bank?
Okay.
What if you write a check on a bank account that has $1 million in it, but for some reason the bank improperly debited your account and attributed that to somebody else? The check bounces. Do you go to jail for that?
See, I just can't imagine that that's equivalent to what we're talking about, Your Honor. What if he didn't pay child support? You wouldn't, I don't think you'd be asking me that question. He has an obligation to pay child support until he files a petition to modify. He has an obligation to pay spousal maintenance until he files a petition to modify. What if, and I'm not sure if it's appropriate for me to ask Your Honor a question.
I'm sorry, but where does it say petition to modify anywhere in the 2017 order? It says an order of assignment, or...
I don't think it has to say that. I think 25327 requires it.
But you just said that it did.
I didn't mean to say that.
Okay.
What if my client's share of his retirement had only been $500, and so it didn't eat the entire $1,000 that he owes?
What if the
Would
court...
he have been obligated to give her notice then?
Let me ask you a different one. What if the court had said, husband's obligation shall be $1,000 per month until wife starts receiving her share of his retirement benefits, at which point husband's spousal maintenance obligation will be reduced to $100 a month? Does he have to file a petition then?
No.
Okay, so here the court prescribed a formula for the reduction rather than a specific amount, but the formula was capable of being computed as a sum certain.
But who gets to decide that? Shouldn't there be
The court
notice?
did in 2017.
Who gets to decide how much he gets to offset of her monthly reward? What if he had received less than $1,000? In this instance, he received more, but she didn't receive notice. He just stopped paying. Well, even in your own recitation, Your Honor, it says once she begins receiving. That's correct to my case as well. She didn't start receiving.
Well, that goes to your interest argument clearly, and I think any payment she's entitled to receive that's a judgment does carry statutory interest. That seems pretty hard to argue with.
But the reality of this order, in ordering that we reimburse him, means
The principle.
that the court is considering, as of 2018, when he unilaterally stopped paying, didn't tell anybody in the world, just stopped paying, that it was he no longer had a spousal maintenance obligation in that month without having filed a thing. So if they're saying there's no longer an obligation as of that month, then I think that's why the court also didn't award me interest on what we believe was owed during that month.
Okay.
From then until now.
Is there any
or until then.
dispute as to what once the payments started being made and parts were withheld for your client, is there any dispute as to what the spousal maintenance obligation should have been under the 2017 order at that point?
Once he paid her and we finally became aware of what her monthly entitlement was going to be, which we didn't know the entire time prior, no records of, then we immediately withdrew our petition to modify prospectively.
Well, her monthly retirement to what? To spousal maintenance or to her share of the retirement?
Her share of the OPM retirement.
Okay, so her share of the OPM retirement benefits was good enough that it reduced the spousal maintenance award down to where we don't even need to argue about it anymore.
That is
so what
correct.
would have been the point of the petition?
Okay, so let's say she had seen that back in when he retired in 2017. She was in a different financial situation back then. She would have had an opportunity to, if he had filed a petition to modify spousal saying, well, now she's getting this amount, so she's no longer entitled to this amount, she would have been entitled to be heard on that. She would have been entitled to say, we had a marriage of significant duration. I moved across the country 45 times to benefit his military career. I am still not in a place where I can support my own needs without his assistance, despite the fact that I'm getting this OPM. She would have had an opportunity to make that claim.
She does. She had the opportunity to file a petition to modify upwards.
I mean retroactively, September 2018 when he stopped paying. I didn't get that chance to address that with her in September 2018 because he just stopped paying. He didn't, he just stopped paying. There was no order that allowed him to do so.
If he had not made the lump sum payment after she filed her petition, if he had not made that payment and then during the course of those proceedings, OPM releases the funds, would you still be able to go after him for that money?
He effectively hasn't paid it because my client's been ordered to pay him $36,000 back. So
No.
He's getting that back.
Do you understand my question?
Yes, I think that my position is that his obligation to pay spousal maintenance did not stop in September 2018. It did not stop until he filed a petition to modify spousal maintenance, which he filed in this case. He filed in the pendency of this case.
It didn't stop until she received.
Per 327.
It didn't stop until she received the money, right?
If that's the answer, that would benefit me, Your Honor, because I agree with that.
Okay, but it may benefit you. I'm just trying to walk through this.
I agree.
So the order provides that once she receives the money, the obligation effectively stops, right? She wasn't receiving the money from OPM not because of husband, but because OPM made an error, as I understand it, and that error may actually wind up carrying interest consequences for husband, but had OPM done its job, she would have been receiving the money at the same time she was entitled to it, correct?
I agree. I'm not sure fault of a third party obviates his obligation to pay spousal maintenance. I wonder if I could save my last minute 30 for a rebuttal.
Sure.
Thank you, Your Honors.
Thank you.
Good morning. May it please the court. I'm Michael Rupert. This is my colleague Edward Walneck to my right. We're here on behalf of the appellee, Colin Dawson. I think there's a couple of issues that have come up in this appeal, and it seems like there's about 6 that have been briefed to this court. The contempt one seems to be of some interest here. And to put it simply, I think there's missing information that the wife should have brought at the time of contempt. What the willful disobedience was.
Well, okay, but we're sort of past that at this point.
Correct.
Contempt is not within our appellate jurisdiction. So why don't we go to the point your colleague last made, which is kind of the crux of the issue. If she has an entitlement to money from OPM, but she's not getting it, does that obviate the need to pay spousal maintenance?
I think in this case it does. In this instance, husband was not receiving those payments from OPM. The statements that were provided to the court as evidence explicitly showed that there was a deduction from husband's retirement benefit that was to go to wife. Wife waited to bring that to husband's attention, and he worked with her to attempt to resolve that issue. Now, the money may not be in wife's explicit possession, but it is being held by another third party for her.
And then it was paid out in a lump sum as arrearages, essentially.
Correct.
By OPM.
Correct. And then she continued to receive her monthly payments.
Why is he not responsible for the interest for the period of time that she did not have that money?
I don't think it's husband's responsibility to rectify the finalization of...
Well, it's a judgment, and judgments carry statutory interest. How can it not be husband's responsibility?
He was not the cause for the delay in the payments
I don't
from
think
OPM.
the statutory interest on judgments talks about who is the cause for delay. It just says you got a judgment, this is the interest that runs on it.
Correct, but that would entitle wife to spousal maintenance during that period of time as well.
Well,
and that would be a windfall to
Might
wife.
that be a question for the legislature then? Because they didn't ask us to engage in a fault analysis when we apply interest to judgments.
Correct. It's not in the legislation. It's not in the statute.
So where are we
it's an
supposed to
outfall.
make up this fault inquiry?
Well, I think at this point, the trial court made a decision of equity to resolve this dispute between husband and wife.
If only our equitable powers could trump legislation, but they don't. We are duty-bound to follow legislation to the letter. We don't have the equitable discretion to simply ignore what the legislature prescribes.
In this instance, we also have a court order that explicitly provides what steps would happen when wife begins to receive retirement payments.
Which she didn't for years after she was supposed to.
But husband did not withhold that from her either. And those funds were being held for her by another entity, which, again, there's questions as to what exactly was the slowdown in her receiving those payments. But those payments were being held specifically for her. Husband couldn't go to OPM and say, why don't you pay me?
No, but if
and I'll
husband
give it
wants
her.
to avoid interest on the judgment, he could have made the payments and then sought a recoupment from her when the OPM awarded her share.
Which ultimately is what's happening here. Husband made a lump sum payment of $29,000 to wife in February of 2021 and began paying another $1,000 in spousal maintenance going forward. And ultimately, wife got her lump sum payment, and she also ended up in the situation where she had an additional $36,000.
Isn't that the fact that he made the first lump sum payment and then continued to pay $1,000 a month? Isn't that an admission that it was his responsibility during the time that OPM wasn't paying?
I think there was confusion as to what was happening for husband. He was in the middle of litigation, and in good faith he made the payment with the express thought that he could seek a reimbursement eventually of those payments made to wife.
But he could
which
have had that same thought in 2018 and avoided any interest obligations because his judgments would have been satisfied.
However, wife waited almost a year to notify him when they were flying across the country that she wasn't receiving those payments from OPM. Husband had no reason to believe that she wasn't receiving those payments. His statements that he received reflected that deductions were being made for wife. He had no reason to believe otherwise.
Well, I suppose at one level, had he complied with the court order and filed a new order of assignment, it would have brought the issue to the fore earlier, giving wife a chance to contest that, saying, hey, I'm not receiving these payments, so you can't reduce your order of assignment at this point.
I don't think there's anything also stopping wife from filing a petition to enforce the
No, but wouldn't the
spousal
burden
maintenance.
rest on the person who already has the obligation by court order?
Yes, it
So
does.
that burden wasn't met here. What are we to do with that?
Well, I don't believe that the order in the May 2017 order for husband to file the income withholding order is a condition precedent for the reduction in spousal maintenance for when those deductions in husband's retirement.
No, but it could
going
be
to
argued
wife.
to be a condition precedent to his reduction of the amount he's paying out. It's not a condition precedent to the substantive amount he owes, but the way we do spousal maintenance and child support payments in most jurisdictions, he has an ongoing assignment until he files a new order. But here there's an old order that requires him to pay a greater amount, and he simply doesn't do it.
Looking back in time, the May 2017 order provides that husband's maintenance obligation will be further reduced
Right.
by the amounts mother
I think it says
receives.
shall, but I'm not going to go there. But it does convey to the average reader that there's going to be a reduction. Sure, that's the substantive obligation. The procedural means by which those payments are withdrawn and transferred is the order of assignment, as I'm calling it, or the income withholding order, which was not changed. So, I mean, how do you not comply with the income withholding order?
At that time, husband had retired from Border Patrol. The income withholding order against income he was receiving through employment was rendered, essentially ineffective. He retired nearly a year after this May 2017 order went into effect.
So that's an even better reason to file a new order, because the new order now has to apply not to his employer, but to his pension plan.
His pension plan was already complying. The pension is not spousal maintenance, to be clear.
No, but the pension was paying, presumably pursuant to a quadro,
Correct.
an amount as part of a property settlement, which then offset a spousal maintenance obligation, right?
Correct.
So your point then is that there was no payor to whom an income withholding order could be directed because she was now receiving property settlement as opposed to maintenance?
Correct. Her property
all right.
settlement had...
I understand your reasoning there.
Okay.
Yeah.
Thank you. And to bring that to a head, the counsel for wife, he makes strong arguments for ARS 25327 applying in this situation. Just to provide distinction, though, there was no modification that was sought, and there was no termination sought through husband's petition. The petition was for a reimbursement. This is effectively an enforcement of a decree that was already in place. Husband is not seeking or did not seek to change that decree that had already been put in place. That May 2017 decree was the effect of a previous petition to modify. The modification had already taken place, and wife to argue that 25327 applies here, I don't know if it's effectively trying to put a backdoor into contesting a modification that had already taken place, but her opportunity to appeal a modification that had already taken place years ago, that time had already expired.
And her opportunity to petition for a brand new modification, though, continues, I guess, for life, right?
It's lifetime spousal maintenance.
Right. So she could always say, wait a second, I think spousal maintenance should now be $20,000 a month.
Correct, but not issues
But
before
not in
this
this
court
court.
today.
Yeah, okay.
Now, to get to the reimbursement award, that the court had ordered for wife to repay the $36,000 to husband. I know we addressed it a couple minutes earlier, but again, I think that at the end of the day, without that award, wife is looking at a windfall in damages here, or a windfall in an award of $36,000 for monies that she already recouped through OPM.
But she never recouped the interest that she is legally entitled to receive. OPM didn't apologize for its delay and furnish her interest.
Correct.
So under the law, she's out money that she's entitled to.
If the court is to find that the period between September 2018 and February 2021, she was entitled to interest, then potentially, but that interest is de minimis to the amount that she's ultimately received, the $36,000.
Well, the interest may be less, but the interest is in play in this appeal, and it seems to me that the order pretty clearly says that the maintenance award will be reduced when she starts receiving. Not when it is sequestered, not when she's entitled, but when she receives. And she didn't receive for a long time, right?
Not directly, but
Not
again,
at all.
the money was being held for her benefit by another entity.
Well, I'd love to tell my mortgage lender that. I'm holding it for you. Don't charge me any interest. I'll get you there in a couple years, I swear. That's not the way it works. She was entitled to some payments, either the property settlement payments, which she was not receiving, or the spousal maintenance payments, which she was not receiving, and the law provides for interest. So I don't even see why there's controversy over the interest.
Well, I will also argue that counsel for mother did not cite to any authority as to why she would be entitled to interest in this action and has waived arguments
How
for
do
that.
you waive a statute that just describes how judgments accrue interest?
I don't believe he cited the statute at all anywhere in his briefing.
So if you don't pay a judgment, normally you do not have to go to court to litigate the judgment to collect on it, right? You use normal means of collecting judgments, and the statute provides a means for a court dealing with the collection issues, not with the substantive issues, to calculate what the value of the judgment is at that point. It is self-effectuating. Why do you have to come to court with a statutory cite to get what the law already entitles you to?
I think in this instance, wife didn't bring the argument, or wife brought the argument for interest, but her positioning was unreasonable as found by the trial court for why she'd be entitled to those additional funds.
Okay, but here we are now on de novo review. Why is her position unreasonable?
Well,
She's not getting anything she's entitled to. The law provides for interest. Why is it unreasonable for her to ask for it?
Well, I don't believe at the trial court level she provided evidence as to what those interests would amount to, leaving the trial court to make that determination on its own. I don't believe that she's appropriately cited to her authority at the court, this court level, for why she should be entitled to interest either.
Is there any authority for anything you're saying? In other words, the statute does not contain an exception for those who do not come to court bearing citations. It just provides for the calculation of interest. Do you have any case law that says if you don't invoke the statute expressly in a court, the statutory entitlement vanishes?
No case law to that exact question,
But that's
Your
what you're
Honor.
asking us to hold.
I argued in our brief and cited to a case. I apologize, I don't have the case offhand, but I did cite to a case that holds not citing legal authority in your briefing
Well,
can
that's
result
an
in a
awfully
waiver.
generic proposition with which we're quite familiar. I don't think you need to bring case law to support the idea that waiver exists as a doctrine. I'm asking if there's any case law to say that waiver exists or can exist in this context under the interest statute.
Not that I'm aware of, Your Honor.
So you're asking us as a matter of first impression to say that you lose your right to interest unless you properly cite the statute.
I am arguing and asking this court to find that wife has waived her request for interest by not citing authority in her briefing to this court.
Okay. I think I understand the position. Thank you.
Okay, thank you.
All right, so assuming we do not find waiver, where are we then?
I believe that, again, a wife is not entitled to a windfall here. The trial court...
Well, I'm not talking about the amounts that were paid by OPM after she had received the lump sum from husband. I'm talking about the interest.
Correct. And I'm not sure as to what...
So waiver is the only argument to prevent her from receiving interest on the monies she did not receive during the period of time?
Well, we are still arguing that the court did, or the May 2017 order did reduce the amount of spousal maintenance to 0 as of September of 2018, and she would not be entitled to any spousal maintenance beginning at that point in time. I think we've discussed it briefly, but again, the monies being held for her benefit by another entity, husband doesn't have those monies. Wife has them held by another entity, albeit she didn't ask that entity to hold those monies for
Sort of
her.
a constructive possession?
Effectively, yes, Your Honor. But at the end of the day, husband did not have the monies, and husband still paid spousal maintenance in a lump sum later on in time. However, those monies were still being built up from the division of the retirement funds, and they were building up for wife in an account presumably held by OPM. How the accounting works, I'm not sure. But the money is still there for wife. She's effectively in possession of it.
All right.
To my last point, the trial court awarded husband his attorney's fees in this matter, and it's an abuse of discretion standard. The court had received AFIs, is my understanding, previous to the trial, and the court explicitly held and made numerous factual findings as to why it believed the wife's position was unreasonable in this matter, and wife has continued her position of exactly the same in the trial court up here, and the trial court found those positions were unreasonable, and that is what resulted in an award of attorney's fees to husband after China doll affidavits had been submitted to the court, and the court reviewed those. I'll close with, I believe the trial court did state it very well at the end of the day. Wife is not entitled to a windfall. There was an equitable result after a trial was held and evidence was received by the trial court. And ultimately, wife has acted unreasonable throughout this litigation in many of her positions, namely, seeking contempt of husband down at the trial court level for what has happened here. And that leaves me to my final point, is that we are requesting our attorney's fees at the appeal level as well from this court based on those same reasonings of wife's unreasonable positions in this litigation. If the court doesn't have any more questions, I'll yield the rest of my time.
Thank you.
Thank you.
May I approach?
You may.
Does yield mean I get his time?
No.
Counsel, I want you to respond to opposing counsel's argument that you've waived your interest argument by not citing authority.
So it was part of my original petition, and I cited case law throughout our brief. We did not present evidence of what the arrears would be in family court. The request is always a referral to the clearinghouse in order to do an arrears calculation with interest. I think spousal maintenance, I don't recall, so I don't want to say whether it's being paid through the clearinghouse or not. I think it was. But I think the statute says we get 1% plus a judgment in a court, gets 1% plus prime, and I didn't feel like I needed to quote that statute for purposes of the trial court.
And which statute are you referring to?
I think it's 44, I'm so sorry, I didn't put it in this, 44 something? It's in Title 44. I just quoted it to a client the other day on a different case, and it basically says if it's a judgment issued in the courtroom and it's not for, there's one exception that doesn't apply here, then the statutory rate is the prime rate as published in blank plus 1%, which I think right now would be about 8%. If I could say, it's kind of equivalent to a child support modification, the windfall argument. It's kind of equivalent to a child support modification. If one child drops off, dad doesn't file a petition to modify for 3 years, he's going to get that money because he didn't put mother on notice that he was seeking a petition to modify. If he's required to put her on notice that he's seeking a petition to modify spousal maintenance, it's still not a windfall. It's a court-ordered obligation that has not been properly changed. And as to attorney's fees, we are asking you to reverse the court's opinion or the court's ruling that my client pay attorney's fees. And one of your honors asked, isn't the fact that he paid his $36,000 an indication that he thought, that maybe he owed it? He absolutely did. His attorney pled, because I pled that as well. His attorney pled at the lower level that he recognized there was a risk and he wanted to make sure that risk wasn't there. So isn't that an admission that my client was reasonable in, even if she lost, that she was reasonable in asking for the interest, asking for the spousal maintenance? If we do nothing else, I recognize that.
Well, it's one thing the question of whether she was reasonable in asking for the interest for the money she was entitled to and didn't receive, and that she was reasonable in going to court to seek out the money that she was not getting otherwise. The question is, was she reasonable after receiving another lump sum, which was supposed to be in lieu of, after receiving monies that she's receiving essentially twice and receiving a windfall, was that a reasonable position? I think that's what we're all looking at.
That was not pled after she received the payments. She pled that in her initial petition more than a year before we went to trial. At the time of trial, we were asking for interest, we were asking for attorney's fees. That's it, and they were asking for reimbursement. And so she wasn't asking for that at trial.
Right.
That had been swallowed by the payments.
That's not something she would have pled or asked, because when she goes to court asking for the monies that she's not receiving, she doesn't know that he's going to make a lump sum payment.
Right.
and how the OPM monies are going to result. But the question is, once she's in the middle of litigation and he pays her and gets caught up, and by your own briefing, you say, she admits he's up to date.
Right.
And then the question is, once she receives that other monies, why did we not say, okay, just pay me the interest that you owe me and we're done, and here's the overage that I received?
We wanted attorney's fees, we wanted interest. They had filed a petition to order the reimbursement. So we were going to trial. I just wanted interest and attorney's fees, and they were asking for her to be ordered to reimburse the $36,000 that he paid during litigation. And so I didn't have a choice to avoid trial. Counsel was certainly unwilling to pay any interest, certainly unwilling to pay any attorney's fees. And
couldn't you have said that? Couldn't you have said, we will give the overage back, but we still need the interest, and we don't want to pay attorney's fees?
I don't believe it's appropriate for me to tell my client to give the overage back. He didn't file a petition to modify. I've been doing this 30 years, only this. You have to file something. The case that I quoted you that's not publishable, they have a far more stringent formula as to how her spousal maintenance will go down. And even that court said, yes, we know what was supposed to happen, but he still has to file a petition to modify to warrant that to start occurring. So right. I thought she was entitled to
even though the court has already said it will be modified, or it shall be modified.
Yes.
That's an unusual fact. In most of these cases, the order is simply open-ended, and it has to be cut off. This order contained its own cutoff.
But it gave us no idea what was supposed to happen, and we were not ever made aware that he had retired. And when she asked him about getting her payment, she's still not receiving it. She doesn't receive it for more than a year, 2 years after she notified him that she wasn't receiving it.
All right. Thank you, counsel. Time has run out, and I think actually, in effect, you received the minute and a half or more. But it's fine. It was due to my questions, so no problem there. We do thank you for your arguments. Thank you both, and for your briefing. This matter is now under advisement, and we will issue a written decision in due course. We're at recess.